thank you everyone for coming tonight, and I will turn it over to Professor Asli.
Great. So I am delighted to have such a great turnout for this event, which is entitled Bringing the War on Terror Home, Islamophobia and the Erosion of Civil Liberties Post-9/11. This event was actually part of something that was driven by a student initiative. A group of students, some of whom are present here today, came last year to ask the CRS program if we would do things broadly about the construction of racial identity in Muslim, South Asian, Middle Eastern communities, also with some focus on the Iranian community. And so this is actually the first of two events that we're having, the second of which will be in the spring, and will focus more on construction of identity, and will feature Sohail Dalakzai and John Turanian. But this first panel is addressing the crisis that some of these communities now face and the ways in which that crisis has produced dynamics that also contribute to racialization of Muslim, South Asian, Middle Eastern communities. And we have an incredibly distinguished panel of speakers to address exactly that question, beginning with Arun Kundnani. So I know that bios are going around, but because not everybody got bios and they are still circulating and so on, I'm going to actually go ahead and describe a little bit the background of each of these speakers, also because they may or may not be familiar to you, depending on your degree of familiarity with these particular sets of issues, but I do think it's important for you to get a sense of the constellation of issues that people are addressing, work that they're doing, and backgrounds that they come from. So Arun is going to be our first speaker, and I'm just going to introduce everyone now, and then we'll turn to the panel, and then I'll take the ball back a little bit when we get to Q&A, but I'm just going to introduce them in the order in which they're speaking. Arun Kundnani is currently serving as a professor in media, culture, and communications at New York University. He is the author of The End of Tolerance, Racism in 21st Century Britain, and the former editor of Race and Class, published by the Institute of Race Relations in London. Prior to joining NYU, he served as an Open Society Institute Fellow, and in that capacity, he completed his most recently published book, The Muslims Are Coming, Islamophobia, Extremism, and the Domestic War on Terror. And we actually have copies of the book here, and I strongly recommend it. So for any of you who are really interested in the topics that we're addressing tonight, this is a wonderful opportunity to meet the author, purchase the book, and so forth. After Arun, we'll have Ahilan Arulanantham, who many of you may have had some opportunity to interact with, because very fortunately for us, we are able to regularly invite him to join us here at UCLA. He's a deputy legal director at the ACLU of Southern California and a senior staff attorney at the ACLU National Immigrants' Rights Project. He has successfully litigated a number of cases to protect the rights of immigrants, including several large class actions. He has been named one of California Lawyer Magazine's Lawyers of the Year in the past for his work at the intersection of immigrants' rights and national security. And in 2007, 2008, 2009, and 2012, and this is probably not adequately up to date, he was named one of the Daily Journal's top 100 lawyers in California. He has served as a lecturer in law at the University of Chicago Law School, where he taught a course on preventive detention. You should pay attention to that phrase, preventive detention, and hopefully it should raise for you some questions. Is this a system that we have in the United States? Can a course be taught in this topic? The answers are yes, as you're going to hear from panelists today. And in 2010, he received the Arthur Health and Human Rights Award by the American Immigration Lawyers Association. Our third speaker is Yaman Salahi, who is a staff attorney in the National Security and Civil Rights Programs at Asian Americans Advancing Justice, the Asian Law Caucus located in the Bay Area. He focuses on advancing the civil rights and liberties of persons affected by post-9/11 federal and local government policies and practices, particularly with respect to Arab, Middle Eastern, Muslim, and South Asian communities. Yaman was previously an Arthur Lyman Fellow here at the ACLU of Southern California, where he worked on litigation related to post-9/11 government surveillance programs at the local and federal level, in addition to community education, public advocacy, and other non-litigation initiatives. So I am delighted to be on this panel together with these panelists, and looking forward to not just really excellent presentations, but a lively discussion afterwards. But with that, I'm going to turn to Arun.
Okay. Thank you all for coming along. I'm having my first full day in LA in my life, so I'm kind of enjoying that. I thought I'd begin just by going into a little bit about the motivation for the research that I've done on these issues that's in the book, and then kind of trying to think about some of the background to these issues and some of the kind of personal stories as well that I've kind of shared in the book. So I guess round about 2009, 2010, when I first started thinking about this research project, I one of the things I noticed was that whereas in the period of the Bush administration, you had this kind of high-profile debate about the war on terror, right? So you had a debate where people were saying, is it right under certain circumstances to torture someone, which is a kind of shocking thing for society to be debating, but that was a debate at least. And should we be going for a war of aggression in Iraq? Again, it's not a great thing for us as a society to be debating, but it was a debate. And so the Bush years, for me, when you think about the war on terror, about these kind of high-profile debates going on. And then under the Obama administration, particularly in the first 4 years, there's a kind of silence about these issues, right? And so that was very striking to me that that somehow now we'd gone from a period of kind of debate about what is the right way to do counterterrorism to a kind of consensus, an unspoken consensus, an unspoken set of assumptions. And so what had started off as this kind of rewriting the rules kind of idea under Bush had become the new normal, right? It had been normalized, right? And so it's no longer something that was being debated, and yet the continuities were obvious, right? So although you had the desire, if not the reality, of trying to shut down Guantanamo, what we weren't talking about was all the kind of mini Guantanamos within the federal prison system, right? While you had the kind of notion that we would no longer do extraordinary rendition, where we will be extrajudicially transporting people around the globe to be tortured in one country or another, we've found ways to do that with a kind of legal veneer, right? Whether it's through extradition or some other process, right? And so again, these kind of things are all about the kind of continuities with the Bush years there. So I wanted to kind of research what is actually happening with counterterrorism, and how has this thing become normalized, right? It's particularly within the domestic space of the United States. And so I spent a year traveling around the United States in 2010, doing interviews with FBI agents who are working on counterterrorism, people in local police departments doing counterterrorism, security officials in Washington DC, in the Department of Homeland Security, National Security Council, etc. Spent some time in Minnesota, in Michigan, in Texas, around New York, and also interviewing community activists and a small number of people who've been labelled as so-called Islamic extremists in various ways, right? And so the book comes out of that period of research. So what I thought I'd do is just to kind of get into these issues a little bit more is begin with a story that I've recently been reporting on, which you can read in more detail on the Nation magazine website right now. This story came out around a week ago. This is a story about a guy called Ahilan Arulanantham, who's a black Muslim guy who grows up in New York City. His father is or was an activist with the Black Panther Party in the 60s. His mother was an activist with an organisation called the Young Lords, which is a Puerto Rican youth radical movement in the 60s in New York. And so Ahilan Arulanantham is then living in Springfield, Massachusetts. And he is working as a community activist, ferrying people to visit relatives in prison, running various kind of community organisations and so forth in Springfield. And a few years ago, he goes to visit Saudi Arabia, right? And when he comes back, he finds that the local field office of the FBI are very interested in his life, and they start approaching him quite frequently and asking him to become an informant on the Muslim community in Springfield, Massachusetts, which he doesn't want to do. He then hears that they've tried to go to his mosque and search the mosque, and they're in various ways kind of putting pressure on him to become an informant. He refuses to do that. He in fact informs his senator about this and kind of raises it with his senator. Around the same time, through a mutual friend, he's introduced to a woman who who proposes to him that they start dating, and after a little while of dating, she proposes that they get married, and they get married. They move in together. She has a young boy. He becomes a kind of father figure to this young boy. They're living together for about a year. And then one evening he's walking back to his apartment from a nearby store, and he's stopped by the Springfield Police Department, who claim to find a gun on him that he's not entitled to own, and he alleges that this gun has been planted on him. 2 days later, while he's being held in a Springfield police cell, the FBI agent who for the previous year has been kind of trying to get him to be an informant turns up and says, okay, well, you've been saying no up until now, but now that you're looking at a possible 10-year sentence, are you ready to make a deal of a lifetime? If you agree to be an informant, this can all go away. Unusually in this situation, he says, no, I'm going to try going to court and have my day in court, and I'm convinced that when I do that, the court will recognise that this gun charge is a trumped-up charge. He soon afterwards discovers that his wife has actually been a paid FBI informant since before they met, and so when this thing comes to court, she then testifies against him, he when he attempts to bring as his defence the information about the FBI's attempt to recruit him as an informant, the judge rules that evidence is inadmissible. So as far as the jury is concerned, this is a straightforward gun possession charge. There's no other background to it, and he gets convicted of 5 years. He gets sentenced to 5 years, and then the police have also, in the meantime, decided that they found another set of guns that they allege are his, and that can add to his sentence another 10 years. And so the FBI is still trying to pressure him to say that can go away if you agree to become an informant. So what this story kind of illustrates is the kind of pressures that people are being put under to become informants, and more generally the strategy that the government has of how to do counterterrorism in the United States now is through a kind of mass recruitment of of informants to do surveillance, right? So we have, as of 2008, the FBI has something like 15,000 paid informants. And so the thinking here is that we can put very large numbers of informants in the Muslim community. We can place them in mosques, community organisations, places where Muslims gather, and we can use them to do two things. Firstly, to gather as much information as possible about people's political and religious ideology, right? And I'll come to that in a moment. And then secondly, to, in some cases, to manufacture plots that wouldn't otherwise exist. All right? So we've seen in a substantial number of the federal terrorism prosecutions that have been brought over the last decade that the alleged plot is one that the FBI informant has actually created, and then through a process of maybe a year or so of being involved in a target's life, of actually then convincing that person to participate in what is effectively an FBI made-up plot. And so it's the FBI that supplies any supposed weapons, it's the FBI that supplies the idea for the plot, it's the FBI that creates this whole thing, and it results in a conviction. Now, what is the I mentioned the idea of collecting as much information as possible about the political and religious opinions that are being expressed in Muslim communities, right? Why is that? Because what shapes this strategy is the FBI's, what it calls its model of radicalization, right? So the FBI, in a similar way to the New York Police Department, has what it calls a model of radicalization. And this is a notion that when someone's becoming a terrorist, they go through 4 stages. And so you can kind of have a predictive model of the journey that someone's on towards becoming a terrorist, right? But these models come out of a kind of body of kind of terrorism studies, so-called academic knowledge that doesn't actually stand up to any genuine scrutiny, but nevertheless it shapes how counterterrorism policy making and practice gets done. So, for example, in the FBI's radicalization model, the second stage in this four-stage process, some of the kind of indicators that someone's radicalizing are things like growing a beard, wearing what it calls traditional Islamic clothing. In stage 3, which is supposed to be one stage away from being an active terrorist, is things like being active in a Muslim social or political cause or organisation, right? So, so if you have this model, then how are you going to prevent terrorism? How are you going to intervene in these second and third stages before someone gets to the fourth stage? Well, you're going to want to have in such a level of mass surveillance that you can pick up these warning signs, these indicators that you believe are telling you when someone's going to become a terrorist. So we have this kind of preventative approach embedded in the strategy that leads to a kind of criminalisation of what would normally be seen as First Amendment protected activities. Then why does that not lead to why are the courts not able to kind of scrutinise this process more effectively so that you have some kind of accountability of the system at that point? Once you're charged with a federal terrorism-related crime, it's almost certain that you're going to be convicted. There's been no acquittals post 9/11, right? It's one of the kind of striking facts about the system that is kind of rarely mentioned. And when we think about, if you think about, a State Department report on the criminal justice system of a country in another part of the world, if one of the data points was, well, in this criminal justice system, the conviction rate is 100%, that would be a massive warning sign that this is a flawed criminal justice system, right? But that's actually the statistic for the United States, right? So 3/4 of prosecutions are settled in a plea deal. The other quarter go to a trial and all result in convictions, right? So, and the majority of these prosecutions are through something called the the material support statute, right? Which is this very broadly drawn notion that doesn't criminalise activity alone. It doesn't criminalise actual involvement in any plot. It's able to criminalise ideological expression, right? Because the concept of material support is drawn so widely. And again, why has this legislation been so popular with prosecutors is precisely because it enables you to prosecute these warning signs, right? The expressions of certain religious and political opinions that you believe are bound up with someone becoming a terrorist, right? And then when we look at the regimes of imprisonment that then result, again here, this is where you need to see a kind of, it's not so much that, the assumption that we've tended to have made under Bush was that Guantanamo is this kind of exceptional space outside of the rest of the way that the federal system works. The reality is there's a continuum between the federal prison system and things like Guantanamo. Guantanamo itself is modelled on federal prisons such as the so-called Supermax prison in Florence, Colorado, where you have many of the same practices: force feeding, prolonged and indefinite solitary confinement, sensory deprivation, continuous monitoring of communication. We have a system where, almost as standard in terrorism prosecution, someone who's in the pre-trial period is going to be in solitary confinement, right? And we know that, all the academic studies on this tell you that if you're in solitary confinement for more than 60 days, it's starting to have mental health consequences for you. And so you don't have a chance in that scenario, after you've been in solitary for a number of months, of any fair trial, right? Because the way in which solitary confinement works is basically breaking your psychological health and your capacity to participate in your own defence, right? This is why people take a plea, because they want to try and preserve their sanity, and they don't really care anymore about having a conviction against them. The final kind of aspect of this that I wanted to just pick up in this introductory point is, so one of the things that this kind of surveillance gaze does is also construct a kind of racialization, right? So when you decide that things like the clothes you wear, your facial hair, when you kind of turn those into kind of indicators of danger, right, which is what these radicalization models do, there's something there that's going on to do with the construction of a racial enemy, right? So we're kind of opening up this question of racialization, question of Islamophobia, right? What the radicalization narrative does is it says there's something about Islamic ideology that turns you into a terrorist, right? So the notion is there's some version of Islamic belief that that kind of captures Muslim minds and makes them into terrorists, right? And this is kind of, I think, the kind of driving notion of how Islamophobia becomes kind of deeply embedded in US popular culture and political culture, over the last few years. For me, we've had this debate played out over the last decade, where you have someone who will sort of say, "Well, Islam is a violent religion," right? And so, for example, Bill Maher did this recently on his show in this clip that I'm sure some of you have seen, where Ben Affleck responds by making this allegation of racism. But usually the way that debate plays out is that someone says Islam is a violent religion, then someone comes back and says, actually no, Islam is a religion of peace, it's not inherently violent, but there's this minority who misinterpret the religion in an extremist fashion, right? And then you have each side kind of trading quotations from the Quran and from the classical sources, which of course means reading all of those things out of context, and it doesn't really settle anything because it seems like both sides have some plausible case to make there, right? And this kind of goes on and on and on. We've seen this repeated over the last decade at least, right? So the point for me is that both sides in this debate are assuming that Islamic theology is fundamentally relevant in either causing violence or preventing it, right? And the real meaning of the debate for me is not what either side says, but this hidden assumption that Islamic ideology is the key to understanding why terrorism happens, right? So the argument I make in my book is that actually, Islamic ideology, theology, etc., is largely irrelevant in trying to understand the causes of terrorism. Actually, terrorism is political; it's not religious, ultimately, right? And when I use the word, what's happening here is that we're systematically associating Islamic belief with violence, right? That's essentially what I think the Islamophobic narrative is about nowadays. And by Islamophobia, I mean not what the word would mean if you took it literally, which is a fear of a religion, but a kind of structural form of racism directed at Muslims, right? So when I was doing research for the book, I spent some time in a place called Katy, which is a suburb of Houston, Texas, and I was in a restaurant there. And on the wall of this restaurant, you see a poster, which is essentially one of those old photos from the early 20th century that I'm sure you've seen of a lynching, right? So you see a body hanging from a tree, and in front of the body you see a group of people looking quite pleased with themselves. Where you'd normally see the back face of the person hanging, instead had been superimposed a kind of stereotypical picture of an Arab. And then the caption on the poster was, "Let's play cowboys and Iranians," right? Whoever had done it obviously doesn't understand anything about the difference between Iranians and Arabs. But so it's a shocking image, but also a very revealing image, because what it does very clearly is show how anti-Muslim racism or Islamophobia is another layer on this much longer racial history in the United States, right? So you have in that poster an implicit reference to the genocide of the indigenous populations of the Americas. You have a reference to Jim Crow segregation and lynching. And then, as it were, the final layer on top of this long history is the depiction of Arabs or Iranians or Muslims as the latest kind of chapter in that history. So I think that's the final piece of this, is to understand how then this these things that we're noticing and observing in terms of how counterterrorism works then connect into these much longer histories, right? So I talked about Ayyub Abdul Alim. Why that case is interesting to me is because he embodies in his own family history the continuities here, right? Like his parents were both targeted by COINTELPRO, the surveillance of black radicals in the 60s and early 70s. And then he, in this generation, is kind of facing very similar practices, but now with a different rationale. The rationale before was we need to go after black radicalism because of its potential for subversion. Today, the rationale is we need to go after him because of his potential for radicalization, right? So the language has changed, but the essential civil rights issues here and the political issues here remain essentially the same. Thank you.
Thank you very much, Arun, for that, and thank you, Asla, for inviting me. Again, I'm Ahilan Arulanantham. I'm an attorney at the ACLU of Southern California, and most of what I do is actually litigation, suing the federal government, either on immigrants' rights issues or on national security issues. And I'm going to talk about a few of those cases here today to put in the context of what Arun was talking about. But I have to say, it's interesting. I've been doing this for 10 years. I've been doing it since 2004. And I feel like I've seen in bits and pieces, in particular cases, so much of what you're talking about at a broader kind of historical, in a broader historical lens. And it really is extremely important, I think, for there to be people who are studying and describing the phenomena, at a broader scale, because it's when you're sort of just kind of working in it on a day-by-day way, it's not always clear to see those trends. One of those, the informant pattern that Arun was describing, is something that we see consistently in our cases. And so I'll tell you one particularly disturbing story about it, which is in a minute. But this practice of going to people and saying, we can get you, you're on the no-fly list, right? The FBI puts you on the no-fly list. It means you cannot fly on a plane anywhere over domestic airspace. Can't fly to, can't fly from, can't fly inside, right? And then the FBI comes and says, we will get you off the no-fly list if you will be an informant. Such as a case that we are litigating right now. Or another one where a Somali asylee, somebody who's won asylum, but his family is still there, and if he can just adjust and get his green card, then he can bring them. And the FBI comes and says, if he applies and it takes forever, and his application doesn't get decided, and then the FBI comes and says, we can speed that up for you if you'll just become an informant. And the reason why that's happening is because they've put essentially a stop on it, right? And there's a policy which permits this. So that's a pattern that we've seen a lot. There's one other thing you said which I just wanted to say something about. I'm sure people who study, how many people here are in law school or law students? A fair amount of you. Okay. I wasn't sure if there are people from the other parts of the university also here, but I'm sure you hear a description like that about the material support of terrorism laws, and it makes you wonder, right? Because the First Amendment protects political expression. So how can the account here be correct? The case, it's really worth reading. Very, very interesting case. It's called Humanitarian Law Project in the Supreme Court from a couple years ago. I can't remember the exact...
Holder versus Humanitarian.
Holder versus Humanitarian Law Project. Thank you. And it's about one person who wants to give human rights training to a Kurdish group that has been designated as a terrorist organization on the State Department's
The one
list.
we're now supporting.
Right. Yes, which is so ironic, right? Because now the U.S. is having to ally with these same, it's the PKK, it's these same Kurdish groups to help fight ISIS, right? And then the other set of people there are actually Sri Lankan Tamils. I'm originally, my family's Sri Lankan Tamil, who they're Sri Lankan Tamils who want to give humanitarian assistance to people affected by the tsunami and the civil war in Sri Lanka, including in areas which are controlled by a group called the Liberation Tigers of Tamil, or the Tamil Tigers. And the Supreme Court, and they say, but these are illegal because giving any support to these groups, even like blankets and oral rehydration, stuff, or giving human rights training to the PKK appears to be criminalized under the statute. And what they basically say is, we want the court to rule that can't be what the statute means, And the court actually rejects that and upholds the statute. And what they say is, if you want to do political expression on your own, you can do that. But if you coordinate in any way with the group, then what you are doing, when you're doing, it's not independent, but what you're doing is coordinated with them in any way, then that is essentially, that is supporting them, and you're doing stuff that they wouldn't have to do otherwise. So, even something as innocuous as giving, diapers or tents to someone, during, as part of tsunami relief, essentially what the court was saying was like, well, if you don't do it, then the LTT has to pay for it themselves, and that's money that they can use for something else. And of course, the problem with that view is, right, if you want to be the editorial writer, right, that costs money too, right? But the logic of the court's opinion really is that as long as you're doing it with them, you're coordinating with them in some way, then it can be criminalized. So yes, it's, I agree with your account. It's sort of shocking that you would actually that could possibly be true, but it is. The last thing I would just say, sort of preliminarily, is most of what I do is civil litigation against the government, like I said. So on the one hand, it's not really great news to hear that the courts haven't been able to stop any of that. And of course, it's true, right, that here we are in the situation where 13 years after the 9/11 attacks, and it doesn't appear that the country is less Islamophobic or more protective of civil rights than it was in 2002 or 2003, right? But on the other hand, there have been situations really entirely on the civil side. I'm not sure that I can think of like one case, maybe on the criminal side, but there have been some cases on the civil side, not many, where courts have taken steps against this. The most recent one, was sort of on my mind, was actually the challenge to the no-fly list. And there have been a few cases now, including one just I don't know now, maybe a month and a half ago or something like that, a case called Latif, L-A-T-I-F, and I would encourage people to have a look at that. There's another one called Ibrahim, also two really interesting challenges to the no-fly list, where the court said it isn't actually permissible for the government to not let you fly on the plane and give you no reasons, no hearing, nothing, so that there's no redress for that whatsoever. So it's a lot of bad news, but I won't say it's entirely bad news. So I wanted to talk about something sort of closely related to this, which is countering violent extremism, or CVE, countering violent extremism. Probably you can tell even from the name that it's like a logical outgrowth of the things that Arun is talking about, right? And it's a campaign which is now being pushed by the FBI and the Department of Homeland Security to go into communities all around the country and encourage partnerships to prevent radicalization, the exact things that he's talking about. I wanted to talk about that today because the program, this is a sort of relatively recent rollout from the summer of this particular federal program, and they picked 3 cities that they wanted to pilot as the leads for this, and one of them is Los Angeles. And the others are Boston and Minneapolis. And so as it turns out, the greater Los Angeles area is now receiving a lot of federal money. It's actually coming through the mayor's office in order to create programs to counter violent extremism in the greater Los Angeles area. There have been some meetings already. I was not invited, but there have been. And I think it's a fair question to ask for people who are in Los Angeles, right, and a community of people. I think it's a fair thing to ask, like, do we want this in our community, Now, you might think, like, well, what could possibly be bad about that, like stopping, violent extremism? But as you've heard here already, there's more complexity to this than initially meets the eye. And I wanted to talk in particular about 3 sort of aspects of the historical frame, particularly to Southern California, although I'm sure you could say the same things probably about other parts of the country that people should have in mind as you kind of think about this. And the first one is that Los Angeles, or the greater LA area, I would say, Southern California in particular, has been a really intense site of widespread FBI surveillance on the Muslim communities, all over Southern California since at least 2004, and probably slightly before that. And that's not a very nice thing to hear, but it's really true. This has been a particularly intense side of it. I know this in part because, starting in 2004, we used to hear about it, the FBI going to people's houses. This doesn't happen so much anymore, but they used to go to people's houses early in the morning. They used to go to people's offices and say they wanted to talk to Muslims. And they said, there's not saying there's anything wrong, not that you've done anything, we just want to talk to you. And they would ask questions about, all things on the sun, including, what mosque do you go to and how many times do you pray? And I remember who did you vote for in the last election? A question that came after 2004 and 2006. What's your view about the war in Iraq? What is your view about Guantanamo Bay? So that was something that happened for a long time. I pulled this today from a brief I was writing today, actually. So it was really lovely, some interesting quotes from the former Orange County terrorism chief of the FBI, named Pat Rose. And she said, she was at a community meeting in the Pacific Club in Irvine. She said, there are a lot of interest. She said this to a community of people, friendly people, sort of like FBI friends kind of event. There are a lot of individuals of interest right here in Orange County. And then she went on, she described like the FBI's programs. She said they're planting bugs, they have closed circuit TVs, things like this. In 2006, this sounded like, Star Wars or something, But she said that the FBI often received calls of people wanted to tell them about situations like, a Muslim neighbor who seems to be changing his license plate a lot, or, someone who has an apartment with, just has a mattress and a bunch of computers in it, and that's it. And she said, this is quotes, we live in Irvine. I can't tell you how many subjects' names come up, and they live right down the street from me. I think we need to be concerned with everybody, including our next-door neighbors. Now, that mentality, at the time, actually, it was really interesting. 2006, right? Caused a lot of concern, and people asked the FBI about it. And then there was the sort of community relations person in the FBI, Stephen Tidwell, at the time, gave a kind of a press conference that was pretty public, and he promised people. He said, "We will not send informants into mosques. If we want to come to people to talk to people in the Muslim community, we'll come in the front door, and we will have discussions that way." And literally at the exact same time that he made those statements, he himself had authorized informants to go into mosques in Orange County. Okay, and one informant in particular, a guy by the name of Craig Monte, who for 14 months, a lot of you probably have heard this name, but who for 14 months did dragnet surveillance within the mosques in Orange County, gathered the names, the phone numbers, the cell phones, emails, invited people to come to the gym so that he could get more information about them, on instructions, according to him, just to gather information about as many Muslims as possible. I'm very shortening greatly what could be a very long and interesting story. I would encourage people, if you want, this is also, it's a case called Fazaga v. FBI, F-A-Z-A-G-A, who's a very smart and articulate man and an imam in Southern California, closer to San Diego. And ultimately what happened was he was essentially, Monte tried to radicalize people. He tried to encourage people to violence. People got scared. They reported him to the police and to the FBI. Okay, and then the FBI. It was very interesting. The director of Council of American Islamic Relations, Southern California, Hussam Ayloush, who's a very important, effective civil rights advocate, called the FBI to report that community members are very worried about Monte, and the FBI told him essentially, "Now that sounds bad. You should call the police about that." And he thought that was very odd. He thought that was very, very strange, and made him think that maybe this guy's actually an informant. Later, it turned out he was. It was revealed actually in the only criminal prosecution that this case led to. This is actually a rare counterexample to what you were saying. A criminal prosecution that actually led nowhere and ultimately was dismissed because the government, on its own motion, dismissed it. So not a single prosecution came out of this, but of course it caused a huge amount of fear and concern in the community that the FBI was doing this. Right? We filed a lawsuit about that. Challenging the dragnet surveillance, a lot of the information that he had gained, the fact that it was discriminatory, that the surveillance was obviously of Muslims generally, right? And the government asserted the state secrets privilege. They acknowledged that he was an informant, right? But then asserted the state secrets privilege and said that we cannot allow this litigation to proceed because doing it would reveal information which would threaten national security. And the district court actually agreed with that. And the case was dismissed, and we've appealed that, and actually that was the brief that I was reading from, because we're working on that now. And then I think that's a very important historical context to put in place when we hear the government saying "Oh, come gather information about our community to worry about the people in our community who are radicals." To remember that it comes against this backdrop, right? That didn't end in 2007 when Craig Monte sort of was revealed. I could talk about this more as well, but there's been other information, other lawsuits that have come about it. Yaman actually has worked a lot on another one, a case called Gill v. the Department of Justice. But it's about the move of the FBI to enlist state and local law enforcement into the practice of gathering information on Muslim communities through a program called the Suspicious Activity Reporting Program and these data centers which are called fusion centers. And essentially what the FBI has done is it's taken extremely broad criteria, the kind of criteria that you're talking about, which includes a lot of political activism and mere associations, and then told state and local police departments to gather information on those things and then report that to the FBI. So the FBI can put it in its own kind of central databases for its own uses. Uses like altering the immigration processes for people or altering the way they get treated at the airport and things like that. There's just a couple really priceless stories I have to tell you about these. Right? There's an American guy, Pakistani origin. He goes to the Santa Ana train station in 2011 and meets his mom there. His mom is wearing a hijab. And he walks around to kind of look for where he's going. He's going to an employment office there. Some other person sees this and reports it as a suspicious-looking Muslim who appears to be looking at the infrastructure, the transportation infrastructure in the train station, right? But that's sort of hilarious, right? But then what happens is that report gets sent to the FBI, and the FBI then holds database information about this report of this person and goes back to the local law enforcement and says, investigate this, right? There's another similar one of a guy, also American citizen. He works for a computer company up in the Bay Area, and he's in purchasing. And so he goes to Best Buy and tries to buy a lot of computers because he's a purchaser for a computer company. That's like his job. And they report this, what was the term for that? Purchasing unusual quantities of materials, right? And again, this gets like picked up. This is suspicious activity and gets sent to the FBI and kept in a database, Now, apart from this, a huge waste of money, right? A huge waste of money, and that's a terrible reason. And there's better things to do with that, and we should care about that. But even apart from that, I think it's important because and this is sort of the last thing Arun was saying. We have also seen manifestations of where this is used to surveil people and keep information on people who are political activists. And this is sort of the last piece of it that I just wanted to. Again, I'll just refer you to it. There's a fabulous article in The Intercept. Do people know what Intercept is? Everybody should know what Intercept is. Intercept is the news organization that was started by Glenn Greenwald, Laura Poitras, the people who had reported on the Edward Snowden allegations. And they have a really fantastic piece coming out of information that was gathered through the Snowden leaks of surveillance that was happening on people in the Muslim communities. Okay, and there's a bunch of people who are surveilled. It's very disturbing, but there's three that are really interesting that I think it's really important people to know about. Faisal Gill, who is a Republican military veteran who worked in the Bush administration in the DHS, in the Department of Homeland Security, and he is a target of surveillance by the FBI, by the NSA at the behest of the FBI, and this is revealed through through this. Asim Ghafoor, who I actually know a little bit, he's a civil rights lawyer who's done Guantanamo representation and other kinds of work on behalf of Muslims. And then the executive director of CARE, actually, Nihad Awad, who obviously is the executive director of a very large civil rights organization in the United States. And so I think that really is the kind of final piece of it, is that it's not just that you have dragnet surveillance and this going on, but the effect of this then is to radicalize, to criminalize, or at least make suspicious civil rights activity, which over time can have a really corrosive effect on the country, a corrosive effect on the democracy. And so I'll close just by saying, countering violent extremism, if it is anything like the prior programs that we see in the past, it should give us real pause, give us real concern. And I think it should also we should ask, when you hear violent extremism, right, or you hear terrorism for that matter. I don't like to use the word terrorism because I still don't know what it means. And I feel the same thing is true of violent extremism. Violent extremism could be about Sandy Hook, right? It could be about so many things. It could be about gang violence. It could be about so many different things. It could be, violent extremism. It could be about the foreign policy of many countries, including ours, right? And so I think that the question you have to ask is, like, why is it Muslims that we're particularly interested in? Why is it this kind of violence that is more of a concern to us than other kinds of violence? And I think those are important questions to ask as we kind of are in this cultural moment and trying to understand the policies that the government is promulgating. So I'll stop there.
Ahilan, there's never a dull day. So I'm going to be talking, we work on a lot of the similar issues that have been discussed both by Arun and Ahilan, but we also do a little bit of work on addressing what people call the chilling effect of this kind of surveillance. And so there's a very clear chilling effect that results from the overbroad surveillance that people like the FBI and the NYPD do. But what we also focus on, especially on youth on campuses and university campuses, is a chilling effect that's not only caused by fear of that kind of government surveillance, but fear of sanction by university administrators, fear of activity and involvement and smearing by off-campus organizations. And that particularly takes place in the context of student activism and academic research related to the Middle East, and especially around Israel and Palestine. I think it's really important to connect this to kind of back to some historical narratives. And UCLA is actually a good example of this because in the 70s, there was a lawsuit brought by a history professor who I believe is still here against the LAPD. And he had alleged that the LAPD was sending undercover informants into his classes and into other professors' classes to take notes about what was being done. And obviously, the undercover officers weren't there to get an education. They were there compiling these dossiers on political opinions of students and professors. And he actually got a very remarkable decision by the California Supreme Court at the time, which I think states very eloquently what the dangers of that kind of intrusion in academic life can cause. So I'll just read a little bit from the opinion. And so the justices say, in the course of classroom debate, some thoughts will be hazarded only as the trial balloons of new theories. Yet such propositions that are tentative only will nevertheless be recorded by police officers, filtered through the minds of the listening informers, often incorrectly misstated to their superiors, and sometimes maliciously distended. Only a brave soul would dare to express anything other than orthodoxy under such circumstances. But the classroom of the university should be a forum of free expression. Its very function would largely be destroyed by the practices described in the complaint before us. And so what is interesting about that is that the wrong is really phrased in terms of the effect of surveillance and not necessarily the act of surveillance instead. And so I think it leaves room for us to identify other causes of that harm, aside from police surveillance, for example, that nevertheless create a toxic environment for scholarship and academic freedom and student organizing, really. When it comes to, for example, undergraduate student activism, particularly for people who are coming from these communities that are facing the brunt of the post-9/11 war on terror, either domestically or abroad, there is a very marked chilling effect that's not only coming from fear of sticking out, but also even that fear has been integrated through parents and through communities sometimes. Keep your head low, just get through school, do what you need to do. And that has a very corrosive effect on the ability of those students and those communities to engage in the civic environment that they live in and to really benefit from their education. So it all takes place under the framework of the First Amendment, but I'm going to be talking separately about two legal issues, one that mostly affects student speech and one that is mostly affecting faculty freedom, academic freedom related to faculty. With respect to the student speech rights, there has been a wave of complaints brought under Title VI of the Civil Rights Act of 1964. And Title VI is a law that prohibits race, national origin, and color discrimination by recipients of federal funding, including probably all universities and secondary schools and primary schools. And that not only prohibits discrimination by the institution itself, but also what's called a hostile educational environment that can be created by student-on-student harassment, so peer-on-peer harassment. When administrators are put on notice of such an environment, they have to take steps to mitigate that environment and ensure that it doesn't become so severe and pervasive that it prevents students from obtaining equally the benefits of an education on the basis of one of those protected characteristics. And so what we've seen in this context, despite clear policies from the Department of Education that this is not intended to infringe on First Amendment protection, we've seen these complaints really focus on political activism by Muslim students, Middle Eastern students, South Asian students, particularly with respect to Israel and Palestine. And so I'll use a couple of these examples just because I think they really help. It's better to tell the story through stories rather than in the abstract. But in 2011, a UC Berkeley alumna sued the university alleging that it failed to stop a hostile environment against Jewish students. And it claimed that the hostile environment was caused by groups like the Muslim Student Association and another group called Students for Justice in Palestine, which held events on campus known as mock checkpoints, in which student activists kind of don costumes where they dramatize Israeli military checkpoints. And the message that they're trying to deliver is that they oppose those checkpoints. But, ironically, the complaint itself is laden with anti-Muslim sentiment, which accuses groups like the MSA of fostering a pro-terrorist agenda and having ties to various terrorist groups around the world. So despite the fact that it is a civil rights complaint, it's impugning the motives and really smearing other communities on campus. And I'm going to read one paragraph from that lawsuit, which ultimately was dismissed on First Amendment grounds, because I think it conveys the goal of what's what is happening here on the ground. So the paragraph says the plaintiff experiences at the 2009 and 2010 checkpoints were terrifying and demeaning in extreme degrees. She describes the frenzy of those military uniforms and carrying realistic assault weapons. The soldiers holding realistic assault weapons and other participants shouted and yelled at passing students, "Prepare to be stopped. What is your religion?" The first time she was stopped, she was absolutely terrified. No one before had ever stopped her while carrying an assault rifle and yelling. She was ashamed and terrified for weeks. So there's a political irony in this complaint, which is really in the phrase, "No one before had ever stopped her while carrying an assault rifle and yelling," which is exactly the message that the students creating this drama are trying to deliver, that the real checkpoints are what they have issue with, right? And so you have one group of students that is identifying what they see as a human rights violation, and then you have this other student who's saying that identifying and talking about this human rights violation itself creates a hostile environment for me. And I do want to make clear, I'm not here to argue for one side of this political issue, because the fact is that the growing amount of activism on campus and the growing amount of faculty and academic engagement with this issue has raised separate questions under the First Amendment that have broader applicability beyond this issue. So I'm not going to be arguing about the merits, but just on the First Amendment issues themselves. But this kind of complaint is actually prototypical of a wave of complaints that we've seen around the country. I'll raise a couple more examples to kind of show that it's not something that has been brought solely by private parties, but has actually been perpetuated by California UC administrators, California State Legislature, and university administrators around the country. So in 2012, for example, the state legislature passed a resolution which identified the following two statements as statements which create a hostile environment. Literally statements from the resolution itself. So to say the following, they said, creates a hostile environment: Israel is a racist or apartheid state, or Israel is guilty of heinous crimes against humanity, such as ethnic cleansing or genocide. So the merits of those statements aside, that's not the point. The point is that to say that describing a political entity's actions it's as violative of human rights or as a form of genocide or whatnot is itself a violation of somebody else's civil rights on campus. Really silences, it frustrates the entire purpose of the university and the entire political freedoms that we take for granted under the First Amendment. And you can imagine that applying that rule to any other state would leave virtually no room for criticism of any state, including our own government. And that was a House resolution passed, I think, unanimously by the state legislature without dissent. And those similar claims were echoed by the University of California Office of the President's campus climate reports in 2012. So I'm going to describe a few more of those complaints to see how this language of hostile environment has been marshaled in this political context. And then I'm going to go into why I think some of these claims are problematic before I talk once more about the academic freedom issues. But, it would be one thing if these complaints were addressing instances of hate speech on campus. So, for example, harassment, use of swastikas, use of anti-Jewish slurs that were targeting Jewish students on the basis of race, religion, or what have you. But by and large, in 99% of these complaints, it's targeted at political speech, stuff that you wouldn't take as suggesting racial animus on its face. So one other example in the UC system is a Department of Education investigation prompted by a complaint against UC Santa Cruz, which lasted for 2 years. And pretty much the sole basis for that complaint was that a university department sponsored, did not even organize, but simply put its name as a sponsor of a film screening and of a panel discussion about that film. And this was in 2009, after the war in Gaza in 2008-2009. And the allegation was simply that by sponsoring that event, the university was fomenting a hostile environment for Jewish students. And I actually spoke at UC Santa Cruz while this investigation was pending, and one of the administrators responsible for scheduling programming there kind of mentioned to me that they were reluctant to continue sponsoring these events until receiving federal guidance from the federal government about the acceptable parameters for these kinds of discussions on campus, which is really quite shocking to be in a society where we're waiting for a directive from the federal government about how you may or may not discuss a particular political controversy. So a couple more examples from the East Coast, just to see how this rhetoric is deployed. At Barnard earlier this spring, there's a common banner space on campus. You reserve it, you go through the administrative protocols. A student group did that, and they put up a banner with university approval in one of these reservation spaces that said the following. It said, "Stand with justice, stand for Palestine." And next to the text, it had a pre-1948 map of Palestine. And the university received a complaint that the banner was offensive and threatening, and that the map itself could be, quote, deeply threatening to many Jewish students. And so in response, Barnard removed the banner and actually has put a moratorium on placing any banners in that space. So here's an example where this kind of, a lack of backbone really on the university administrator's part to say, well, we take these kinds of claims and assertions seriously, but this claim does not rise to the level, ends up frustrating the free speech rights of anybody else on that campus to use that banner space. And it's also been deployed against other pretty standard tactics like use of mock eviction notices. This recently happened at NYU and at Northeastern when it happened. In this tactic, students distribute these parody eviction notices to student dormitories, which are supposed to bring light to demolition of Palestinian homes in the West Bank. And those were also described as disrespectful and intimidating, that left students feeling attacked, threatened, and unsafe, even though they didn't reference students in any way, shape, or form. But at Northeastern University, that was enough to lead to a student group's suspension, which was only lifted after engagement by the Foundation for Individual Rights and Education and the ACLU of Massachusetts. I think, too, one important aspect of this to highlight is that it's not solely an issue of partisans attacking one another because they disagree on the issues, because there's nothing new about that. That's, every political dispute can be characterized that way. But also one of really shameful institutional failure to protect the university as a ground for free discussion and for this kind of engagement. So, for example, we have countless examples in the UC system where UC administrators have basically echoed the same kind of rhetoric. So at UC Berkeley, the chancellor recently issued a statement on the occasion of the free speech movement, ironically enough, concerning civility, in which he said, "When issues are inherently divisive, controversial, and capable of arousing strong feelings, the commitment to free speech and expression can lead to division and divisiveness and undermine a community's foundation." So in other words, the clear message is divisive issues are not for discussion at a university. Where are they supposed to be discussed if not at a university? That might be a good rule for Thanksgiving dinner with your family, but the motto at UC is "Let there be light," right? So pursue knowledge and do your research and do what you need to do. It's not play it safe, and it's not keep it down. And so I think that really clashes with the entire purpose of a university environment. That's my quick run through of the student speech issues. But we also have a recent attempt to apply similar tactics on academic and faculty research. So I want to kind of bring back that statement from the California Supreme Court decision where the justices say, only a brave soul would dare to express anything other than orthodoxy under such circumstances. I have a pretty positive impression of most of my professors. I think they are mostly brave souls, but you don't want an environment in which only the bravest of the brave are willing to share their research and to pursue certain courses of inquiry. The most recent attack, which is quite troubling, concerns the Title VI of the Higher Education Act. Title VI of the Higher Education Act provides federal funding and has since the mid-60s to universities around the country to promote foreign language and area studies. And obviously the priorities in that regard have tracked more or less the geopolitical issues of the day. So what started as something that really prioritized Russian language and Russia studies now, well, it had for a time been more focused on the Middle East. But the funding decisions in that regard are supposed to be based on neutral criteria like the success and academic worth of a program, not political criteria like loyalty to one set of political views or another. But a few weeks ago, well, now it's last month, a couple of organizations launched a campaign urging Congress to amend Title VI of the Higher Education Act in order to require more government, effectively surveillance of the academic centers in order to coerce viewpoints that they say are more favorable of Israel in those programs. So the basis for this entire call for reform is an allegation that actually focuses on UCLA's Center for Near East Studies. And the allegations are twofold. One, that the center has what they describe as an anti-Israel bias. And two, what they say is an anti-Semitic bias. But the entire call for reform is kind of embedded in this framework where they say that the academic centers all around the country are, quote, hostile to the United States, the West, and Israel, and that the programs are, quote, not working as an effective pipeline to intelligence and national security agencies. So their recommendations are really quite startling. They recommend that departments of Middle East studies, that tenured recommendations be made outside those departments. They recommend that the government require oversight panels that are composed of people from outside of Middle East studies. So in other words, people who are not trained in the field and have no qualifications in that realm whatsoever are being asked to go in there and set the proper narratives. Interestingly and tellingly, the precedent that they cite for this are President Nixon's efforts to nix Title VI funding because of opposition by academics to the Vietnam War. So that's the best and it's proud precedent that they cite in their report. So it's clear that this is all about kind of trying to mold academic work to fit within a certain political orthodoxy. Am I good on time?
2 more minutes.
2 more minutes, okay. So I'll go quickly into what the report says about UCLA's Center for Near East Study to point out some of the flaws in the methodology. But basically they claim that 93% of events that were hosted by the CNES exhibited an anti-Israel bias, and that 75% exhibited anti-Semitism. So first, on the notion of bias, the use of highly subjective political labels like anti-American and anti-Israel to judge academic work is simply an oversimplification of what's going on. Academic work is judged based on methodology and based on adherence to scholarly standards, not some reductive label into whether you can categorize something as anti-American or anti-Israel. But the definition that's used to measure bias is so broad that it even includes events that were co-sponsored by the Jewish Studies program at UCLA, or were co-sponsored by J Street, which is self-describes as the pro-Israel, pro-peace group. So it's a very narrow definition of bias that really goes and assesses the events to see if there's any viewpoint aired that is critical of Israel, despite other viewpoints aired at the same event. That is an event that exhibits anti-Israel bias, and it's without regard to the merits of the claims that they're challenging. The second is the overbroad definition of anti-Semitism, and they have Appendix F in their report of the study, a list of, I think, 9 examples of anti-Semitism, which are basically the following. Example 1, a speaker claimed that Zionism views Palestinians as subhuman, undesirable, a population that should not exist, and accused Israel of denying absolute basic inalienable human rights of Palestinians. So clearly debatable statements that, you take aside, you argue them on the merits, but nothing that on its face can reasonably be construed as exhibiting anti-Jewish animus. The final thing I'll say about that is the report really does a disservice to the Center for Near East Studies because of the complete lack of perspective. So it suggests when it talks about anti-Israel bias that that the academic center really only criticizes Israeli policies. But if you just do a cursory review of the events that the center hosts on other countries, and I'll read out 4 titles for you, and you can tell me whether it sounds like it's lauding these other countries in the Middle East. It just suggests that academic reviews, for some reason, are only critical of Israel but not critical of other countries. So, for example, the persistence of the past, how violence and genocide in Ottoman Turkey affected our world today. It doesn't sound very pro-Turkish or pro-Ottoman. Stopping the nuclear threat from Iran. It does not sound like a pro-Iranian event, right? Egypt, stillborn revolution. It doesn't sound like a pro-Egyptian government event. I think those are the main points I wanted to highlight about that. But I think the main takeaway from this is that it's very important that this be seen as a academic freedom and First Amendment issue, and something that is of interest and concern not only to people who are academics in Middle East study or people who are activists on one side or another of the issue, but rather something with ramifications for the place of the university overall. Thanks.
Okay, so we began 10 minutes late, as you know, so we have about 25 minutes for Q&A. And I really welcome students to ask any range of questions, or of course any members of the audience, relating to any of these presentations, which covered a real gamut of bird's eye view of how practices fit together to create an environment that really racializes Muslim, South Asian, and Arab communities, some of the actual surveillance practices here in Southern California, and litigation strategies to challenge them, and then the implications of the chilling effect of these overall strategies and the ways in which private organizations and individuals are also deploying similar tactics to try to limit speech around issues that appear to be either critical of American policy or critical of other policies, but again, are forms of dissent that are to be policed, particularly when they come from these targeted communities. So we have a very rich set of presentations, and I really invite any set of questions connected to them. Okay, so I see 2 hands, and we'll take both questions and then come back to the panel. Go ahead.
This is for Yaman Salahi, and I'm obviously the former director of the Center for Near Eastern Studies at UCLA. I am the target of lots of these reports and FOIAs. I, of course, am particularly interested in any litigation strategies that you might have.
Oh. Yeah.
Go ahead, yes.
Okay, well, as someone who was hung up about whether they would get a foreign language and area studies fellowship this year, they didn't tell us until like the end of 4 days after the fiscal year, and there was talk of them. The issue is always they don't know if they're going to keep the funding, if they're going to cut off the funding, and it was talk of some years previously Cornell lost it, some other universities, and of course it created havoc with a lot of our financial funding. So I'm wondering if it has something to do with that universities with centers that are particularly controversial in terms of the Middle Eastern, if it just affects everyone, whether you're in East Asian studies or you're Asian studies and so on. And then a lot of the comment by the chancellor reminds me so eerily of kind of what the Chinese government always says about how they have to maintain order and harmonious society, and also the sort of uproar around the cartoons about Prophet Muhammad in Pakistan and how they would shut down Facebook, to keep things under control. And so I wonder if when things come to a head, if things come into court, if there people ever fall on, Shunk versus the United States and the whole argument about, shouting fire in a crowded theater, and if when they get backed against the wall, they rely on those arguments and how credible, the juries find them and the public, because in other more autocratic countries, like those arguments, like, well, there's not much room for argument, but that's what the government says, like, that's why we, you know, try to keep things harmonious.
Sure. So I'll start with your question. So I should have mentioned that so far as I'm aware, there has been only one lawsuit that was dismissed at the motion to dismiss stage, so before discovery, before trial, and the judge had dismissed it with leave to amend, saying basically that most of the alleged conduct was protected under the First Amendment, but there were also other deficiencies for the Title VI claim in particular. Particularly no severe and pervasive environment, no sign of deliberate indifference. But in the four investigations...
Those are suits by somebody complaining about the hostile work environment.
Right.
Yeah.
So, yeah, I should have said that as well. Under Title VI, there are two ways to enforce Title VI. One is a private cause of action for intentional discrimination. So an individual can file a lawsuit against the university for failure to mitigate a hostile environment that's severe and pervasive and that it's on notice about. The other way is to file a complaint with the Office for Civil Rights in the Department of Education, which is probably the far easier route because the Department of Education will do all the work of investigating it for you. And in the four Department of Education investigations, those were also dismissed, but they were investigations ranging from 2 to 8 years. So UC Irvine was under investigation for 8 years. UC Berkeley was under investigation for just over a year after a year of litigating the same complaint. UC Santa Cruz was under investigation for 2 years, and Rutgers was under investigation for 3 years. But in all of those, the ultimate decisions actually ended up being very good. Talking about how in higher education, you know, a reasonable student would encounter robust and discordant expression, and finding that all the challenged political expression was protected under the First Amendment. But the problem in this context is not necessarily what a court will ultimately decide, but that it's so hard to bring a First Amendment lawsuit for the kind of infringements here that it takes a long time before you can mitigate that. And then the threat of the complaints themselves, even when they're meritless, create an incentive for university administrators to kind of steer clear of anything that could possibly put them in a situation where they could face investigation, which harms their prestige, takes a lot of work and everything, and potential liability. So what we are seeing as the biggest problem is actually the chilling effect that is like self-policing by the universities that's going far into the direction of protected First Amendment speech and not sticking to actionable harassment under Title VI. And then I think that's actually a question that's better discussed in private. Yeah. Yeah.
By the way, just to clarify one thing that might be on folks' minds, Title VI is appearing in both cases. So the Title VI of the Civil Rights Act is the one that allows for these particular recourse for individuals or to bring complaints or lawsuits versus Title VI of the Higher Education Act, which is the funding act that is currently now going through reauthorization and may be subject to the various kinds of surveillance that was described, whereby there would be content-based restriction potentially of funded centers that look at research on the Middle East or possibly other area studies areas. But okay, I saw some hands that began to tentatively shoot up. Okay, so 1, 2, and 3. So I'm going to go Kathleen, you, sir, and then Professor Carbato, and then we'll come back to the panel again.
Thank you very much for the description of the situation. I'm curious about what you think are viable solutions and how we should implement them. Is this a short-term or an issue that we can address in the short term, or do we need to be thinking mid-term, long-term strategies, and how tied into the political developments of the country do you think solutions are as well?
Yes, sir, go ahead.
Oh, thanks. There's a book called The Terror Factory by Trevor Aronson. Aaron may or may not know it, but it details how the FBI essentially frames mentally ill and vulnerable characters, and it recruits agent provocateurs by essentially criminal blackmail. We'll put you on the fly list. We're going to frame you for a crime. And in your example of the former Black Panther, the son of the former Black Panther and Young Lords activist, they couldn't do that unless they had contacts in the Springfield Police Department to frame the guy, and unless they had cooperation from the judge to go along with it and to preclude any content, okay? Now, I noticed this sheet here describes the topic as the war on terror in quotes. It's obviously, I suggest, a consensus among you that it's not actually a war on terror. So perhaps one of you can get to the bone, to the marrow, and say what is a war on terror.
It's hard to follow up on that provocative question. I was wondering, Arun, if you could say something about what we might call comparative Islamophobia, looking at the way in which it's manifested itself in these contexts here. Your book isn't formally framed in that way, and I've not finished reading it yet, but it's a terrific book. But I was wondering what the axis of differentiation might be, particularly in the context where in the UK there is this tendency to think about these issues in terms of class, and I think Islamophobia really challenges that in deep and profound ways, even if it's the case that the dominant ideology of class still suppresses the work that race might be performing. And Ahilan, and is it Yaman? I was wondering where you see the greatest erosions. I don't study First Amendment law terribly, but I do focus on Fourth Amendment. And it seems to me that it's gone almost. And I don't know if you would tell the same sort of story about First Amendment jurisprudence vis-a-vis its intersection with, quote-unquote, the war on terror.
Okay, so I'm going to invite the panelists to respond, but just to take responsibility for the quotes around the war on terror phrase, the reason that those quotes appear is because it's an undefined term, meaning there is no definition that's provided either by the government or by anyone else of either terror or of the war on terror, and yet the phrase is used systematically as if we understand or know what it means. And so at least for law school purposes, I think it's more accurate to put it in quotes as some kind of term of art that's being used without definition. But all right, so I will now turn to the rest of the panel.
Yeah, I mean, so pick the war on terror question. I mean, terrorism is a term of art. Before we get to what a war on terrorism might be, the kind of simplest definition of terrorism is acts of violence that have the aim of publicising a political cause. But actually, the way we use the word terrorism is never consistent with that. We always use it to describe certain groups of terrorists, but then other people who are actually doing political violence, including our own government, never get called terrorists, right? And that's kind of the part of the way the word works. And that's kind of what the war on terror is about normalising and making seem necessary and rational certain kinds of violence by and making those kinds of violence invisible by making other kinds of violence very visible, right? Now, why do we have to do that? Is kind of what you're asking, right? And
why it's being done.
Why it's being done, and so for me, there isn't a kind of conscious kind of there isn't a kind of group of people who sat down and said we're going to invent this thing called the war on terror for this and this reason, and there's a kind of hidden kind of conspiracy behind it all like that. What I would say is this: when you have a society like ours that has a particular kind of economic system that depends on the ability to go around the world inflicting violence to sustain the economic system that we have, right? And whether you want to define that as capitalism or some particular kind of capitalism that has this propensity to go around the world and use violence in those ways, you need some way to justify that, right? You need some way to dehumanize the victims of that violence in order that you can have a situation where, where we can have wars that result in hundreds of thousands of people dying, and somehow we're all kind of okay with that. And that's what the war on terror ideology does. That's what Islamophobia as an ideology is essentially about. It's about dehumanizing the Muslim victims of our government's violence, right? And then what's a lot of what I write about is then the way that then comes back into. That's why the war on terror coming home is kind of a good title for what we're talking about here, because then it's about how does that violence then come back into the United States, right, and boomerang back. So for me, it would be some kind of argument along those lines. It's a structural thing rather than a conspiracy. In terms of solutions, I think that this is not some temporary phase that we're in, right? Where this is certainly not about some kind of spontaneous reaction to 9/11, where we kind of through the kind of fear and the kind of immediate emotional reaction to those events, we've somehow done all this stuff, and as we kind of calm down as a society over time, we're going to kind of get our senses back. Right? That's not what's going on here. This is about something, as I say, if that was going to happen, that would have happened with the end of the Bush administration. What we've seen actually under Obama is very illustrative in that sense, in the ways in which it's become normalized, right? So the neoconservatives kind of invented the kind of ideology of the war on terror, but it's the Obama liberals who've normalized it, right, and made it a part of our everyday way of thinking, right? And so it's now a permanent state of emergency, right? And so in that sense, then, we do need to think about not just waiting for this to go away, but how we actively make it go away. And I think the kind of strategies of kind of advocacy in DC are not going anywhere, right? There just simply isn't the purchase within the DC political process for that kind of change to happen. I think the way we need to think about this is about a more general cultural change in society that we go about achieving through exactly the kinds of conversations we're having today, right? And I think I think there's a couple of things that we need to be very insistent on in doing that. So the first thing is, there's been a bit of a tendency for us to do an argument where we, in response to Islamophobia and in response to the civil rights issues that have been thrown up over the last decade, we kind of say, yes, there's some bad Muslims over here, but we're the good Muslims, right? And that division might be done by saying the American Muslims are the good Muslims, it's the ones over there in other parts of the world that are the bad ones and the problem. So please understand we're different. Or, divide up the American Muslim population, so we're the good ones who are kind of living in the suburbs and trying to just wave the American flag and be all American, and the bad ones are these Somalis over here who've just recently come, or these other ones over here who've just recently come. So we can have all these divisions. This is all just playing into the problem, right? And we need to understand that, that we have to get away from this good Muslim, bad Muslim, moderate Muslim, extremist Muslim, all these different ways of framing it, because that's all part of the actual narrative that we're trying to oppose, right? And then the second thing is look for the ways in which alliances can be built across different communities, right? So one of the things that's been really effective in some of the campaigns against surveillance in New York, in the Bay Area, and actually in LA as well, is where you have grassroots alliance building, where you say, okay, this issue of surveillance is not, it's something that affects Muslims in particular ways, but it's also something that affects African Americans. It's also something that affects homeless people. It's also something that affects people who are trying to make welfare claims, right? And so you start to build up a much broader sense of all the different ways in which these structures of surveillance that might well be introduced in the name of the so-called war on terror actually impact on all kinds of other communities as well, right? And so building those alliances, I think, is important. I think we have a young generation of people who've grown up, right, in the last 14, 15 years in the shadow of this kind of post-9/11 climate, and possibly, unlike their parents, are much more willing to challenge it, right? And I think there's some very energetic and interesting campaigns emerging with that young generation. I think one of the things that the kind of suppression of free speech on campuses that we've been talking about, one of the things that says is, there's a sense in which they're losing the argument, right? Otherwise, they wouldn't need to turn to these kind of methods, right, of suppressing the kinds of conversations that we're having about things like Palestine, right? If there wasn't a lot of potentially successful pro-Palestinian activism happening on campuses, this wouldn't be needed, right? So actually, on things like that, the conversation is shifting in our direction, right? And these are kind of signs of that, even though they're also very repressive. And so I think we can kind of build on all these energies that are emerging, I think, in very interesting ways, and start to shift the conversation and make these connections so that we're understanding the connection between what's happening in the Middle East and what's happening here. On this issue of freedom of expression, one of the most powerful arguments that we should be making is not simply to say this stuff is a violation of our First Amendment rights, right? It's actually to explain what is the harm that comes from suppressing freedom of expression, right? And one of the harms that comes from that is, we have a foreign policy in the United States in relation to the Middle East that is disastrous and has been for decades, right? And one of the reasons it's disastrous, and one of the reasons we keep doing things that lead us more and more to inflict violence on people, we're back bombing Iraq, right? So one of the reasons this keeps happening is because the section of American society that knows the most about the Middle East is prevented from contributing to the foreign policy debate in this country, right? And so we are losing the intelligence that comes from a section of our society to inform a better foreign policy because we've decided that section is not permitted to speak about Palestine or about Egypt or about Iraq, right? So as a society, we end up with a huge loss, right, in terms of the effectiveness and the intelligence of our foreign policy, right? And that's disastrous for America, right? Not just for the Muslims or Arabs or South Asians who feel a chilling effect on their self-expression, right?
There's also the comparative Islamophobia.
Oh yeah. So comparing the US and the UK is complex. To cut a long story short, I think the kind of history of the Muslim communities in the UK is very different from in the US, right? So, in the US, a third of American Muslims are African American, and so the story there is one that goes back through the whole history of the slave trade, plantation system, and then the kind of black freedom movements that come in the 20th century. And then you have this kind of post-1965 immigration, which has a kind of different feel to it, and a lot of that is about people coming into quite suburban settings and so forth. In the UK, and so that produces an American Muslim population that is as diverse as the global Muslim population, right? And diverse as well in terms of its class character as well as its kind of ethnic origins. In the UK, at least until the last 15 years, the British Muslim population is almost entirely descended from the immigration that happens post-war, post-World War II, from India, Pakistan and Bangladesh. So it's post-colonial immigration, it's people coming into the British working class to do jobs that no one else wants to do. And so the kind of character of that experience then is very much shaped by a particular kind of working class history in the UK and the politics that comes with that, a particular kind of history of anti-racism within those communities that's shaped by traditions of anti-colonial politics in South Asia and the Caribbean, that's shaped by takes some inspiration from Black Power movements even in the US, right? So the kind of political character of what that experience looks like is I think very different than in the UK. And then so as well as those kind of differences in the community history, there's really important differences in the in the way then that the system functions, right? The political process is very different in the UK. The criminal justice system is very different. In the UK, we had a policy introduced in 2006 called preventing violent extremism, right, which was countering violent extremism, right, that's now kind of coming to LA just now, is modelled on the British. It's a gift to the world from Britain, right? So that policy is, whereas in the US, that's kind of something that's gradually being filtered out, and it requires all kinds of buy-in from all kinds of different agencies. In Britain, that policy was the idea of one man, Tony Blair, right, who kind of bought into some neoconservative think tank ideas, and basically on his whim could say, all right, every government ministry has to deploy this. I can find hundreds of millions of pounds to deploy it. Every local authority across the country has to deploy it, and we can kind of roll this out top down. It just press a button and off it goes, right? doesn't really work like that in the US with a much more kind of fragmented political process. The same with the criminal justice system, right? You don't have this, here it's you have, I don't know what the current count is, thousands of different law enforcement agencies in the US, right? In Britain, there's like, it's getting less all the time actually in Britain, right? It's very centralised. So the kinds of policies you can roll out in Britain are much more kind of top down, and you just have a small elite that can impose these things very directly.
I just have a little bit to say on these two, and then I'll mostly answer Professor Carvalho your question about the Fourth and First Amendment. On the long-term, short-term thing, the only thing I would add to what Arun said, I agree with everything he said, is just the importance of telling stories. And I think it's really interesting, even within the advocacy community, when our kind of work on sort of counterterrorism stuff sort of started in the 2002, that time, a lot of the focus was on finding plaintiffs who were not Muslim. In fact, the very first challenge to an airport security policy is a case called Green v. TSA, which is a libertarian guy who says, I want to fly to Washington to exercise my right to petition the government or something. It's very kind of manufactured in a way. Although he did really want to do that, but at the same time, and he lost. And then if you look later over time, it was coming to, I think, realize as an advocacy community that you have to humanize. In the same way, there are people in the gay rights movement who will tell you that will and grace is the reason why you now have a lawful gay marriage in most of the country at this point, right? And so in the same kind of way, I think the idea of really kind of humanizing, judges are people too, so they also read the newspaper and watch television, and so I don't think that it's sort of hopeless. I think DC advocacy and litigation are very important in a variety of ways, but they're primarily defensive. I think to really kind of change over time, it does require the cultural shift that comes with telling stories and talking about the harms in a concrete way. On the what is it a war on kind of question, your question, I think the only thing I would add to what everyone said was in Fizaga, and in a lot of the litigation on these issues, actually, the central question, and in the policy debate over racial profiling guidance, which is a huge issue now, about issuing guidance for all federal law enforcement, the central question really is the fact that you are Muslim a basis to make you more suspicious? Right? That's actually the central question. The question is, everybody agrees, it's sort of a national consensus that in theory, in terms of the policy, race cannot make you more suspicious, right? And there's guidance that already says this. In practice, it doesn't work that way, right? But that's what the theory is. But there's actually
just a footnote. Although apparent Mexican ancestry, as a matter of constitutional law, is still a basis for suspicion vis-a-vis undocumented status. That is black letter law.
Yeah, that's actually really that's an interesting one. The Supreme Court said that in Brignone y Ponce's case from the 1970s, right? And then there's lower courts that have come more recently, including the Ninth Circuit, that said, oh, we don't think that can be true anymore because of demographic shift and things. So it's there, but it's this sort of outlier. But religion, whether religion can be a basis of finding you suspicious, is absolute as a legal matter, is a matter of huge dispute that remains. It's a dispute happening right now, actually, in the Obama administration about whether the guidance on racial profiling should include religion or not, right? So I think that, in a way, is a way of capturing. It's not a war on sort of all Muslims in the sense that it's not like the government is going out. And not letting any Muslims fly or something like that. But the question whether the fact that you're Muslim can make you, for that reason alone, more suspicious is really up for grabs. It really is open. To answer your question about the Fourth Amendment and the First Amendment, I agree with you. The Fourth Amendment law is grim. It's sort of shocking. It was already really bad, but it's really kind of remarkable what's happened in this most recent time. Interestingly, most of the bad decisions about it. If you look at the practice of what the government is doing, it's amazing, right? And I'm sure you know this, but for other people, every landline phone call by Verizon, and I'm sure it is also true, and the government has said this is also true of AT&T and Sprint, but there's a piece of paper that was leaked and then was discussed extensively. It is a court order authorizing the monitoring of all the metadata, who made the call, to who it was made, how long it was for, the location, I think, is probably included that as well, of every landline phone call made by any Verizon customer in the entire United States. right? And that was authorized because a secret court, the Foreign Intelligence Surveillance Court, said that there was a reasonable suspicion, essentially that every phone call was related enough to a terrorism investigation so that it could be monitored for just this data. And that's and that's just incredible. It's just stunning, right? And that's the system that we're living in right now. But as a result of those leaks and certain other things which I won't get into, there's actually now a chance to at least challenge the legality of that, because there were challenges. Actually, we litigated them, challenges to the legality of programs that we thought were like that had happened, and we lost them all on the grounds that we couldn't prove that they'd actually happened, right? But that's another one, if you're interested. Amnesty International v. Clapper is a really interesting case. The court goes on and on to explain why we don't have a basis to believe that there's actually surveillance going on like this, right? And therefore can't actually address the question of whether or not such surveillance is actually lawful, right? And then, of course, just like a few months later, it turns out that all of it is entirely true, right? So it's really bad, but I think it's interesting now what will happen, because we're now, I think, going to get, after the Snowden leaks, we have a better chance than we've had before of getting rulings on this. We actually got a good decision in a district court decision in D.C. We lost it in the second in New York, and now they're going up. But your question was really about what's the rest of it. The First Amendment law. We talked about Humanitarian Law Project earlier, and it is a terrible decision, but it is also quite narrow, right? Because really, what the decision is saying is that if you are trying to cooperate with a designated terrorist organization by supporting them through any one of these ways, that can be prescribed, right? And although it's remarkable, it's actually the only content-based restriction on speech which is presently lawful. There was obscenity, and then that died. There were certain other ones, the doctrines, those were all struck down because, in general, most of the First Amendment law, has gotten more permissive, better over time. But that people were shocked, actually, by the result in Humanitarian Law Project. A lot of people, including a lot of First Amendment scholars, were really just shocked because the Supreme Court upheld the content-based restriction on speech. And it is literally the only one that is currently permissible. But it's narrow, and there hasn't been a lot of other litigation. I was listening, thinking about it as I was thinking about your question. There hasn't been a lot. There's been a lot of cases about charitable, the law of charitable freezing and no-fly list. All these are kind of things short of criminal sanction that they can do to you. But in those cases, we haven't really raised First Amendment arguments. It's mostly been due process and some Fourth Amendment arguments. Discrimination, obviously, that's what like Fazanga is about and stuff like that. There's a whole body of detention law, which is really not that bad. It's actually quite a mixed bag compared to the other stuff. So like on judicial review, for example, the Supreme Court said there is court intervention on the question when the government detains someone, they lock you up outside the criminal process because they say you're some part of the war on terror. Right? The Supreme Court actually made very clear that there is judicial review over that if both if it's in the U.S. and if it's in Guantanamo Bay. If it's somewhere else, it's less clear. And whether they can actually hold you or not, there's not really any kind of consensus even now after all this time. So the rest of it, I definitely think the Fourth Amendment is you're living in the best part. The Fourth Amendment is the worst of it, I think, as far as all this doctrine goes. And on the First Amendment, it's really odd actually when you say that now. I mean, it's been a long time. There is a lot of suppression of speech happening in various different kinds of ways, but there's been very little litigation about it for some reason.
Do you want to add anything more?
Just on the national security angle of it, so I like Ahilan's reference to Will and Grace because it kind of reminds me that you really need a lot more than lawsuits and litigation to address these kinds of issues, because the problem is not solely legal doctrine, but the social backdrop against which it's being developed. And so what I see as a crucial role here is for social movements to get involved in this, because currently, as Ahilan said, the issue is, can you treat a religious identification as a basis for suspicion? And in a lot of the decisions around these surveillance programs, for example, courts have either made the suggestion that you can, kind of indirectly, or that it's worth it. So even in the Fazanga decision on state secrets, at the end of it, the judge must feel a little guilty or something because he waxes poetic, starts talking about Scylla and Charybdis, and says, sometimes when you're navigating between Scylla and Charybdis, you've got to throw off the soldiers to save the ship. And so if you read that critically, he's talking about Muslim soldiers, or Muslim sailors, sorry, not soldiers. Yeah, the Muslim civil rights sailors on the ship, and the ship is everybody else. So there's a, it's not said explicitly, but that's there behind the scenes paragraph. In the case against NYPD spying in New Jersey, I think that's the Hassan one, but there are two cases, one's in New York and one's in New Jersey. The judge actually dismissed that. It was also challenging the dragnet NYPD surveillance of Muslims in New Jersey. And the judge dismissed that kind of on two grounds. One was that the chilling effect of the surveillance wasn't caused by the NYPD, but by the press leaking the fact that they were surveilling everyone. And the second one, which is actually quite troubling, was that, well, there's nothing wrong here. Of course, if you're going after Muslim terrorism, you have to go look at Muslims, which is a totally roundabout way of defining the problem. And if you pair any racial or religious marker with a crime, then yes, of course, you're always going to have to go after that group if that's how you narrowly define the crime. But I think it can be fruitful to look at that from a historical perspective as well, because that's precisely the logic that was used in Hirabayashi and Korematsu with respect to Japanese curfews and anti-Japanese curfews and internment during World War II. And so they did take race or national origin and race as a sufficient basis for concluding that a certain community was suspicious in that regard. And you know, Korematsu, everyone thoroughly repudiates it now, but it was actually just cited as good law by Justice Thomas in his dissent to Fisher, the affirmative action case, in which, you know, it's kind of crazy really, because he says, you know, we've only approved racial classifications in two contexts. One was in the national security context in Korematsu, and another is in like very narrow remedying of past discrimination. So the suggestion is that it's actually worse to use race to ensure diverse college constituencies than it is to arbitrarily like subject people to government investigation in the national security context, or detention even, mass detention. So
I want to end our panel on a, it's not happy note is not the right way to put it, but I want to end it on a sort of hopeful note. And we do have a lot of law students in the room, and I guess one question many might be asking themselves is, what kind of career path might I be on, or what could I be thinking about doing, given the position I'm in right now, to actually have a career that enables me to speak to or address any of these issues that are arising, whether for the Muslim community or just more generally around civil rights. And of course, I mean, one thing that's very desirable is to work at the ACLU. You're advancing, Asian Americans advancing justice and so on, but those are a few set of opportunities that are available in a wider, in some ways, matrix of things that people are trying to do through not only litigation strategy, but advocacy and other avenues, but applying a legal degree to actually addressing some of the kinds of things we're seeing. So we talked a little bit in response to Kathleen's question of what are medium to long-term strategies, but what are career paths that are connected to any of these kinds of strategies that members of this audience might take away besides just the very grim picture of some of the directions that civil rights have taken with respect to at least the Muslim community?
Well, I mean, the ACLU and Advancing Justice are two kind of excellent organizations, but there's lots and lots of them. Yes, I said that. Yes. But there's lots and lots of them, and they do work in a variety of different kinds of areas, right? So there's the policy groups, there's the Brennan Center, the Center for National Security Studies. There's groups that really do surveillance in a very sort of particular focused way, Electronic Frontier Foundation and Electronic Privacy Information Center. So taking one set of things, which is like the NGO think tank policy research kind of entity, there's lots of those. There's lots of those that do a lot of really good work. And a lot of them are involved, I think, in sort of shifting the culture, because a lot of the culture is also just the mentality of people who are policymakers, right? And that does happen in a larger societal context, but it's also like its own context. That's one. Then obviously there's civil rights groups that are providing services, legal services and other kinds of services, Council on American Islamic Relations, the South Asian Network. I mean, actually, Advancing Justice is sort of a hybrid. They do some of that, and they do some more like litigation work, like what the ACLU does. So you know, there's groups like that. And then there's a lot of private attorneys. In fact, a lot of the really great work right at the start, like right at the beginning, and in the few months after 9/11, I was actually just starting as an attorney. I was in the middle of a fellowship, Equal Justice Works Fellowship in New York at 9/11. We did a lot of work with detainees, that first like 1,000 people who were detained in New York and New Jersey. I went and talked to a lot of those people. But a lot of the people who were doing that work with me, well, Center for Constitutional Rights was an amazing organization in New York and represented people in the Guantanamo detainees right at the very beginning. They were the first ones to represent Guantanamo detainees, but also private attorneys. Both private attorneys who were immigration lawyers, like private solo or like 2 or 3 person firm immigration lawyers, because so much of this work, so much of what the FBI wants to do and the DHS wants to do is through manipulation of the immigration process. There's a great deal of work. Even now in LA, there are fantastic immigration lawyers who do amazing work on national security cases, who are just private law firm lawyers. And then also similarly criminal defense, really excellent, very robust, superb lawyers who are in like 2 or 3 person firms doing criminal defense cases, paying cases, and they do a mix of things. So, and those are definitely, those are 2 of them. I could sort of talk a long time about. There's a lot of career options available out there, but there's no one path to get to do this work. A lot of different ways to do it.
Yeah, I don't have much to add to that really, but just as a general lawyering point, I would say it's important to remember that just because something does not necessarily have a legal remedy to it and can't be fit into those terms, doesn't mean that there's nothing that can be done about it to confront it. There are still vast problems with the world we live in today, aside from just the stuff related to the national security environment, that maybe litigation is not the best way to deal with it. Going back to the suspicious activity reporting program, it's one thing to get a legal ruling that says, okay, these are bound by reasonable suspicion. That's the threshold for collecting this information. But the fact is that over the past 8 years, you have 78 new fusion centers around the country that didn't exist before, and those are not going to go away when you get that legal ruling, right? That's still going to be part of a new infrastructure, a new form of government that was not there before, and that can't be addressed through law directly. So just please continue to not just be lawyers. Yeah.
Okay, and on that note, please join me in thanking the panel.